investigative, and he should have told me. Okay, it doesn't.
Clear one roll, that bench. No, don't squeeze. Don't squeeze. The bench after the advocate, you move backward. Lillian, you have a floor. Okay, it's understood. You can put it on. The other person? For the prosecution. Yes, good morning to you. Senior Counsel Nyamonti, for the materials that you have supplied, that has also enabled the court to be able to arrive at its decision. I also thank your client for obeying the court directions at all times and also attending court. That's something that the court must appreciate and give credit where it falls due. So today marks the end of the trial, the decision of the court, which I shall now proceed with the judgments. First accused person, Moses Leonokulal, was the first governor of the county government of Samburu. Elected and inaugurated as a governor following the year 2013 general elections. and you ended up serving a successful first term. This position is admitted in the defense and also established by the Kenya Gazette Notice number 3155 dated 31st of March 2013. That was the document which was produced as XP 380A. There is also the other Kenya Gazette Notice 7845 dated 18th of August 2017. That's Exhibit 80B for your second term. This case arose when the governor was serving the second term. Second accused, that is Stephen Sirenga Letinina, was the county secretary at the county government of Samburu and the head of the public service. You also served as the designated accounting officer and the holder for the county executive. Your position is established under provision section 44 of the County Government Act number 17 of 2012. The third, fourth, fifth, sixth, seventh, eighth, and ninth accused persons were county chief officers and heads of department at the county government of Samburu. The chief officers were the designated accounting officers and their holders for their respective departments. The position of chief officers is also established under provision section 44. The first definition is for the term benefits under section 2 of ASECA, which is defined as any gift, loan fee, reward, appointment, service, favor, forbearance, promise, or other consideration or advantage. The second definition is the definition of a public officer, which in the decision of Frederick Otieno Outa versus Jared Odoyo Okello, decision of the Supreme Court petition number 6 of 2014, reported in 2014 KR, arrive at the following finding. Strictly speaking, proper meaning of a public officer is that embodied in Article 260 of the Constitution. The different definition in other statute provisions, such as those that 1, the person concerned is a state officer. 2, any other person who holds public office, an office within the national government, county government, or public service, and a person. In applying this definition to the present, the county secretary and chief officers who draw remuneration benefit from the public exchequer. Therefore, accused persons were all for all intent and meaning, away from the paper trail involved in the pre-qualification, award of local purchase orders and payments, and instead, Hesbon Dadi, the 11th accused person, was the one actively involved in the paperwork. On material presented before me, no act of violation and adherence to the prescribed procedure of pre-qualification, award of contract, or payment can be attributed to the first accused person. To that extent, I find that the prosecution did not prove the element of improper use of office and the mens rea for the charge of abuse of office, only as against the first accused person in count number number 2, private interest, the contracts for the supply of fuel. In the present case, conflict of interest was committed with the full knowledge by the first accused person. The foregoing evaluation of the evidence leads to an inevitable conclusion that there is overwhelming and direct evidence that the governor acted in conflict of interest and acquired direct personal benefits in the contract for supply of fuel. You actively traded with the county government of Samburu during your tenure of 2 terms until you were charged before this court. Thus, this becomes a classical case and an example of conflict of interest. I'll proceed to count number 4 for the offense of unlawful acquisition of public property, contrary to section 45.1 as read with section 48.1 of ASECA. I also deem it fit to address the affidavit sworn by Wesley Nyamache, Senior Prosecution Counsel. Before concluding, it is important to address the concern raised by the affidavit sworn by Senior Prosecution Counsel Wesley Nyamache. The affidavit was relied upon by accused person in their defense and submissions, and indeed, it is a matter the defense has made every whither of. The defense sought to contend that learned prosecution counsel absolved them from blame. These affidavits reproduced below for the record. Now in the judgments, supporting affidavits in support of application, not so motion, in support of applicants, not so motion dated 12th of October 2022. That was the application intended to withdraw this particular matter by the DPP. I quote Wesley Nyamache, Principal Prosecution Counsel in the Office of Director of Public Prosecution, having conduct of this matter, do hereby make oaths and swear as follows: that I'm a principal one, that I'm a principal prosecution counsel and one of the prosecutors in this matter, duly authorized to swear this affidavit on behalf of the applicant. 2, that I swear this affidavit in support of the instant application wherein the applicant has moved this honorable court under Article 157 of the Constitution of Kenya, Section 25 of the Director of Public Prosecutions Act, and Section 7A of the CPC to withdraw charges against all the accused persons herein. 3, that the accused persons herein are facing several counts emanating from the offense of conflict of interest, whereby the first accused person traded the county government of Samburu by use of Oryx service station, an entity he had registered as sole proprietorship in the respect of the tender for supply of fuel. 4, that the second and 10th accused person at the material time were departmental chief officers and or designated county officers with the said county government and played a role in the award of various contracts by signing their departmental local purchase orders as well as the authorizing payment in favor of the Oryx service station. 5, that the matter has proceeded before this honorable court, and so far 10 witnesses have testified with the IO partly heard. 6, that in the course of this trial, the Director of Public Prosecution received information regarding this matter to that effect. A, the first accused person by the letter dated 5th April 2013 addressed to the County Secretary, County Government of Samburu, declared and disclosed his interest in the Oryx service station, annexed herewith and marked WN1 is a copy of the letter. That is the letter on conflict of interest, XB 238. B, that the declaration of conflict of interest was subsequently entered and registered in the conflict of interest register and marked WN2. That's the register that I've said it doesn't accord with the law. C, the county government of Samburu has confirmed that no man was lost with respect to the impugned tender awarded to Oryx service station for supply of fuel to the said county. Annexed herewith and marked WN3 is a copy of the letter dated 22nd September 2022. A letter was written by one of the officers, and I think ESCC should take in interest on those kind of officers. D, County Government of Samburu as equal confirmed that they got value for money following their request for supply of fuel from Oryx service station in accordance with the impugned tender. Averment number 7, that upon review of the supply public prosecution found and be meet necessary to charge the defense. And having considered the submission by all the parties, I arrive at the inevitable conclusion that the prosecution proved the case against the accused person beyond reasonable doubt on the following charges. Accused person, you stand up. All the accused persons. First accused person, Moses Leonokulal, I find you guilty, convict you for conflict of interest contrary to provision section 42.3 as read with section 48.1 of ASECA. First accused person, Moses Leonokulal, and 11th accused person, Nesbon Jack Washirandadi, jointly guilty and convict each one of you for unlawful acquisition of public property contrary to section 45.1. A as read with section 48.1 of ASECA. The amount is what I've calculated. Count 5, I find second accused person, Stephen Siranga Letinina, guilty for abuse of office under provision section 46, as read with 48(1) of ASECA. Count 7, I find that accused person, Daniel. Who is Daniel Nakuo? You are Daniel Nakuo. I find you guilty and convict you for the abuse of office contrary to section 46, as read with 48 of ASECA in count 6. Who is Josephine Namo Lenasalia? I find you guilty for abuse of office and convict you contrary to provision of section 46, as read with 48 of ASECA. Ruben Lemunyetu, who is you are the one. I find you guilty, convict you for abuse of office contrary to provision 46, as read with 48 of ASECA, for count number 11, count number 8. Linus Milton Lonolgenje. Milton, I find you guilty and convict you for abuse of office on provision of section 46, as read with 48 of ASECA. Paul Lomilgani. Paul, I find you guilty, convict you for abuse of office on the provision of section 46, as read with 48 of ASECA. As per account number 10, Bernard Latarasi Lesumat. Bernard, I find you guilty, convict you for abuse of office contrary to section 46, as read with section 48 of ASECA. Lilian Balanga, I find you guilty and convict you for abuse of office contrary to provision of section 46, as read with section 48 of ASECA. With regard to count number 2, and based on the reason that I've given, I find the first accused person, Moses Leonokulal, not guilty for the offense of abuse of office under provision of section 46, as read with 48 of ASECA. Those are the orders, judgment for the courts, and that marks the end of the judgment. You may resume your seats. You can proceed with the application on behalf of the first and the second.
The Honor grants us 48 hours to prepare for that mitigation. And if it is convenient to Your Honor, to my colleagues,
then it will be quite in order. I'll expedite it. So I think that marks the
Nenda hivi. Bado ukote melikonzi. Embe nisongea.
Okay. Proceedings and Anti-Corruption Commission working on the judgment on offences. This includes conflict of interest, fraudulent acquisition of public property, all of them relating to a case where the convict, that is the former governor, traded the county government of Samburu during his 2 terms as governor. The ruling delivered by the court the justice, the people of Samburu. It is a ruling that EACC finds significant in a number of ways. For instance, this is the first corruption case of a criminal nature, the first corruption case of a criminal nature where the court has found the accused persons guilty. In this case, we have the former governor, Moses Leonokulal, the then county secretary, and the other senior county officials. Today, the court has rendered its ruling, and the sentencing will be done tomorrow. The other way in which this case is significant is that it sends a message to all public officers, both at the national and the county governments, that there are consequences when one betrays public trust. When we talk about conflict of interest, such as the one that the former governor has been found guilty of, it is important to remember that conflict of interest is the bedrock of most of the mega corruption scandals that the country is grappling with. Facing these kind of cases involving conflict of interest, which cases are at various stages in the criminal justice system. We have some that are under investigations by the EACC. Those involving 2 governors have just been completed, and the files are on their way to the DPP recommending prosecution. We have other files still involving governors, part of the 40, that are pending review and a decision by the DPP on whether or not to prosecute. And then we have other cases, part of the 40, that are pending before the Anti-Corruption Court. The matters that were in court were 10 until sometimes 2 weeks ago, when one of the cases involving a sitting governor was withdrawn by the DPP. So we have 9. When you remove this one that has been concluded, we now have 8 governors, that is former and current, with the cases pending before the court. The court has also rendered itself on the issue of withdrawal of cases. EACC remains opposed to the withdrawal of corruption cases during the trial. And therefore, it is good that the earlier attempts to withdraw this particular one did not bear fruit. EACC sends a warning to public officials that are engaging in a conflict of interest at the county government and the national government to know that their day in court will come. Some may ask why this case has taken around 5 years. It is because of the institutional capacity that is available within the criminal justice sector. It means that if we can strengthen the critical agencies that are involved in the fight against corruption, that is the EACC, DPP, and the judiciary, so that we have more investigators, more prosecutors, and more magistrates. That means we can be able to handle more cases at the same time. So those with cases who are yet to be subjected to the court process should not think that they are off the hook. When their time comes, action will be taken. The last thing that I will mention in relation to today's case or the ruling is that EACC is no longer pursuing prosecution of offenders alone. Contemporaneous with the prosecution of suspects, EACC is filing civil suits where money has been lost and is seeking to recover that money and return it the same to the public. The case involving former Governor Moses Leonokulal is one of those cases because in addition to the conviction that has taken place today, EACC has already obtained orders from the High Court, from Justice Maina, where the judge ordered the former governor to forfeit the monies paid to his company by the county government. That means that where public funds are used to make payments that are premised on irregular or illegal contracts, such as where there is conflict of interest, that money is recoverable in full, and the EACC appreciates the jurisprudence that is coming from our courts, that even if you did the work, such as it happened in this case, the money paid to you will be recovered in full if that contract was illegal, if it was given in conflict of interest or violation of the public procurement laws. Given that these cases involving top officials are largely revolving around a conflict of interest, this reminds us of the importance of the conflict of interest bill that was recently before the Senate. The National Assembly rejected the amendments that were proposed by the Senate, and the bill is now headed to the mediation committee that has equal members from both the National Assembly and the Senate. And the EACC urges the Parliament to consider passing the conflict of interest bill in its original form, because the amendments that were subsequently made have watered that bill down to the extent that if that bill was law today, then the conviction that has been secured here today would not have been secured. So we are seeking to have a strong conflict of interest law so that it can address the current problem where senior state officials, together with their families, are trading with the county government, with the national government, and as a result, public money getting lost. Finally, EACC has several other cases before the DPP and before the court. We confirm that all those cases have been investigated with the same standards that were used in the investigation of the case where the court has today rendered its decision. That is all, unless there is a question. Remember, the mandate of the EACC is to investigate. So the moment we investigate, we forward the files to the DPP. But in respect to the particular question that you have asked, yes, it is true that on the 6th of August this year, the DPP withdrew the case against the current or the sitting governor of Tarakaniti, Modomituki. That has been withdrawn. To interpret, but the reasons that were given to court are related to sufficient evidence. The court was informed that the evidence on the record was no longer